Hi there, I'm attorney Kelly Longtin from Kelly Longtin Law, and welcome to our YouTube channel. Today I'm going to talk to you about the pros and cons of powers of appointments when it comes to estate planning. So an often misunderstood but common estate planning tool that can appear in estate planning documents is the power of appointment, not to be confused with the power of attorney, and that's in a document that allows you to delegate certain powers to an agent to act on your behalf while you're alive. A power of appointment can be an incredibly useful tool if used properly and knowledgeably. Now, a well-considered power of appointment allows you to maintain significant flexibility in your estate plan now and in the future, even when that estate plan is otherwise considered irrevocable under the law. Though hundreds of pages of books, scholarly articles, court decisions, and tax regulations have been written on the topic of powers of appointment, I hope to help you in this video to identify opportunities in which powers of appointment may be useful to recognize cases in which they could create negative consequences. Let's begin by talking about what is a power of appointment. Now, broadly speaking, a power of appointment is a right granted in a legal document, including in a will or a trust, by an individual to another person. This granted power allows the individual to name someone else, or the individual or the beneficiary, to name someone else as a recipient of all or a portion of the money and property in the future. Now, the power holder is not required to exercise the power. Rather, the power holder simply has the option to exercise it. If the power is left unexercised, then the money and property will pass to those individuals or entities who were originally named in the will or trust as the beneficiaries and in the amounts originally specified. Now, this tool essentially allows for the person making a will or a trust to postpone the decision of who would receive the money and property and grant such decision-making power to someone else who may be in a better position in the future to determine who will receive it. Now, there are a variety of reasons why someone might want to use a power of appointment in their estate plan, including tax considerations, asset protection, and a desire for flexibility. So I just want to go over a couple of examples so I can show you how and why a power of appointment might be used or useful. So let's just say that Sarah creates a trust that's designed to hold her property for the benefit of Dave, her only son, for his entire life, which will then pass to his children when he passes away. However, 3 of her grandchildren have a history of drug use, terrible spending habits, and have even attempted to financially exploit her in the past. While although Sarah wants only her grandchildren to benefit from the trust after her son dies, she wants to allow Dave to determine how much, if anything, should go to each of her grandchildren, depending on how they conduct their lives in the future and what their needs are. Now, Sarah's estate planning attorney suggests that she grant Dave a testamentary limited power of appointment in her trust that allows Dave to distribute the remainder of the trust property according to how he sees fit amongst his children, in equal or unequal shares at his death. This will require Dave to draft a will or a trust that includes a provision that specifies how the remainder of Sarah's trust will be divided amongst his children at his death. Including such a power allows Sarah to maintain some control over who will receive her property, but also grants some important flexibility in her estate plan to her son so that he can take a second look at those family circumstances years after Sarah has passed away. So let's talk about another example. Well, John is Karen's second husband. Karen has children from a previous marriage, and John has never been married, and he has no children of his own. Now, some of Karen's children have been very nice to John, while others have been quite mean to him. Now, Karen has significant wealth and intends to ultimately leave it to her children. However, she wants to provide for John throughout the remainder of his life if he should outlive her. To that end, Karen's estate plan establishes a trust for John that is protected from estate taxes at her death. The income generated on the trust property is paid out to John for his life, with the principal of the property payable to her children at John's death. However, she grants John a testamentary limited power of appointment over certain company stock held in the trust, so that upon his death, he can determine who among Karen's children will receive the stock and in what shares. Karen explains this to her children so that they get the message that if they mistreat John after she is gone, he has the authority to reduce the value of their share of her trust by at least some degree. Her hope is that this will incentivize her children to treat John with a certain level of respect that they sometimes have struggled with during her life. Now, these examples just illustrate just a couple of the more common reasons why and how powers of appointment can be creatively used to build flexibility into an estate plan. There are many other ways to use these incredible useful tools. And it's important to note, however, that they can also create significant risk and lead to unintended consequences. So now that you have a better grasp on the uses and limitations of the powerful estate planning tool, you can better identify in your own circumstances the situations that would call for a use of a power of appointment. You can also identify the existence of powers of appointment in your own estate planning documents or in the documents of your loved ones, and consider whether these are in fact appropriate for your circumstances. If you want to learn more about how powers of appointment can be used to help you achieve your estate planning goals while maintaining significant flexibility in your planning, please don't hesitate to reach out to us if you live in Massachusetts or New Hampshire, so we can sit down with you and discuss your best planning decisions based on your unique needs. Otherwise, reach out to a qualified estate planning attorney in your area to help you work through whether adding these to your estate plan makes sense for you. So I want to thank you for watching. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we focus solely on estate planning and providing effective estate planning to everyday families. If you enjoyed this video and you want to learn more about estate planning, please like and subscribe to our page below. Thank you for watching. I'm attorney Kelly Longtin.